So they have a heavy burden. I mean, that's the whole point of it being non-judicial. We're running on an honor system that the lender's not just randomly foreclosing on houses because they want to.
And they're not filling out affidavits saying that they've met all these requirements when they haven't.
Right.
I mean, that's the idea.
Right. Right.
And the new laws are supposed to make that stick, I think, even more.
Yes.
The lenders have always been required to do these things, but now the new laws are saying, okay, prove that you did it. We're going to take you to task, and we're going to hit you with legal fees if you didn't do it, and if your foreclosure gets turned over or overturned by the courts.
Right.
I see.
Right.
Good.
And I think what will come out of it, too, is when there's this robo-signing and when there are documents that haven't been done correctly, such as assignments of the deed of trust, I think you are going to have standing issues, and that's a defense that you could raise with regards to not just, a violation under these rules, but now you get into, do you even have the right to foreclose? Yeah. So I think this is going to initiate a lot of litigation in a different context about who these servicers are, how they acquired these rights, or did they ever acquire the rights, and do they have the standing to foreclose? I think there's going to be a lot more standing litigation.
Or a lot more thought that goes into a foreclosure sale by a lender.
Yes.
Yeah.
And I think that's the intent. It's not that, if someone's not making payments on their home, they borrowed the money, they owe it to somebody, I don't think anyone's saying that this law is going to erase that factor. I think what it's saying is lenders need to have been held to a certain level of accountability for documenting these things properly. Case in point, there's an attorney that works at the Legal Aid Center in Florida that I met last week, and she has had a multitude of cases where 2 banks initiated foreclosure on the same property because the MERS system that's out there that keeps track of who owns these loans as they're sliced and diced and sold didn't keep track of it right. And so there's 2 servicers that thought they were the servicer collecting on the property, and both of them, sent their files to a foreclosure law firm and separate law firms, and they had 2 foreclosures happening by 2 different banks.
Boy. There's
another case that came out not too long ago where the woman had paid off her house like 20 years ago, and the bank foreclosed. a bank foreclosed because the APN number was wrong.
Where was that?
It was in Florida.
Gee.
Yeah, I mean...
We've had a client here, didn't we, who foreclosure started on him.
And it was supposed to be the house next door. Yeah, the house next door. Yeah. So it's, they make mistakes, so I think it's intentional. Probably never. I mean, hardly ever. Probably a better answer. But
if it's a mistake, it's not intentional.
Well, right. I mean, well, I guess that's true. But do I think they make mistakes that genuinely are mistakes? Yes. Yeah. Absolutely. I think they're overwhelmed. I think it's a volume issue, and these things happen.
But for the for the very reason that we have this legislation, there have been some shenanigans.
Absolutely.
Yeah.
Absolutely. And you have to think, what's the servicer's motivation in doing a foreclosure? Well, it's because they get paid more cash, they earn more cash off of a foreclosure than they do off of servicing a performing loan.
Even a performing loan.
Yeah.
And definitely a non-performing
loan. Well, because a performing loan, they get a certain percentage based off the unpaid principal balance. So if their mortgage payment's $1,000 and they get 1%. Yeah. Okay, great. But once that loan goes into default, they're tacking on fees and additional interest and everything else. What happens? That unpaid principal balance goes up. So even if you get caught up, or you get reinstated, or you get a loan modification, your unpaid principal balance is going to be higher, which means the servicer makes more money. Because it's not based on the services they provide, it's based on a percentage of the unpaid principal balance. If servicers got $5 for every loan payment they collected, no matter what, then their motivation would change. Because they would want to have more people making payments.
Money's a big motivator.
Absolutely. And the terms of how you relation.
Yeah.
And that's the other part of it, is most of the servicers own foreclosure trustee companies. Who do you think does their foreclosures? Bank of America, for example, owns Recon Trust.
Oh, interesting.
Chase Bank owns California Reconveyance. So they're all subsidiaries. So when the foreclosure trustee starts the foreclosure, they have their attorney's fees, the recording fees, the transactional fees, all these other fees that add up, and most foreclosures range between $10,000-$20,000 in fees for the foreclosure trustee.
Oof.
When the sale happens of the home at the auction, the foreclosure trustee and the servicer money of whatever they receive first. Then the rest of it goes to the investor.
They get paid.
They get paid. And if there's insurance held by any of them, sometimes they get paid twice, sometimes 3 times. So, it's understanding those motivations, I think, helps people understand why, when they call the bank and say, well, reduce my principal by $20,000 and we'll call it a day. And the servicer's like, well, no, that brings the unpaid principal balance down. That's not good for me.
Yeah.
And by the same token, just simply reinstating the loan doesn't really do anything for them financially. It's something that a lot of lawyers have talked about, is that servicers are almost at an adverse position with both the homeowner and the investors who actually own the investment, because their financial gain usually is to the detriment to one or both.
Boy. Conflicts.
Yeah, it is. It's interesting because you and I could never be in a business transaction like that.
No.
Or representation like that. But, but we're seeing a lot of investor-based lawsuits against servicers for breach of fiduciary duty and for breach of the contracts with regards to what pooling and servicing agreements say. So that's the biggest thing about Dodd-Frank reform, is it's going to really make transparent who actually owns these loans, so that borrowers can bypass the servicers and try to get straight to who the investor is, to say, hey, here's what's happening. They told me that your pooling and servicing agreement doesn't allow this. Is that true? And the investor comes back and says, absolutely not. Deal. Now the servicer's going to have to, address that issue. So I think the transparency that's going to be created, and again, our next webinar, we're going to talk more about Dodd-Frank, and its impact to servicing, because I think that's going to be a huge change that we all see as consumers. There's a way more intricate changes Dodd-Frank makes with regards to just the financial industry as a whole, but I think for consumers, the changes to servicing, and then the changes to RESPA with regards to how you settle real estate transactions, is going to be, it's really going to change the way things are done. Biggest highlight there is you can't do drive-by appraisals anymore. You have to go and inspect the property. On residential property. So that's going to be a big change.
Are lenders going to make loans anymore?
We'll see. Maybe not the same kind. It might change. But so we are out of time. Appreciate everyone's questions. The webinar is going to be posted on our website. I'm also going to post the bills that we talked about today. They haven't been codified yet, at least not as of this morning, into the Nevada revised statutes, but we'll also have references to that once that becomes available. It usually takes until after October for them to actually go in and revise the statutes, because they wait until all the bills go into effect, so they only have to do one print.
Yep.
But we will have the bills up. You can download them, read them, and we always entertain questions. And again, our next webinar will talk about RESPA, TILA, Dodd-Frank, and all these other changes federally that are going to affect us all as consumers and homeowners. So thanks for everybody attending.
Thank you.
All right. Bye.
Bye.